Welcome to Water Cooler Justice. I'm Chris Robertson, and I've been practicing employment law for over 20 years, helping clients resolve disputes or navigate challenges at work.
And I'm Sarah Goodenough, Chris's legal assistant and soon-to-be paralegal.
Woohoo! That's going to be great. Welcome to episode 13 of the pod. If you've been enjoying Water Cooler Justice, take a moment to follow us, leave a rating, or send your favorite episode to a friend. We really appreciate the support. Today, we have two panelists joining us, Ellen Lowe and Nina Gupta. Ellen is a good friend of the pod, and we're happy to have her back today. Ellen started her career at Gallings and was later a partner at Whitten & Lublin. After a decade of practicing exclusively in employment law and HR relations, she started her own boutique firm, Ellen Lowe & Co., Employment Law. Ellen regularly represents her clients in courts, at tribunals, but is equally well-versed in mediation advocacy, where she assists clients in navigating alternative dispute resolutions and negotiated settlements. Ellen, thanks for joining us again. And Nina Gupta. Nina Gupta is a partner in Gallings with the Labor and Equalities Group. Employment, Labor and Equalities Group. Her practice focuses on a broad range of employment and human rights matters. She is known for her practical and cost-effective, as well as focused approach to employment law and litigation. Nina has advised a broad range of employers from startups to world-renowned multinationals on all aspects of employment law, including employment offers, contracts, policies, compensation plans, cross-border employment, and regulatory compliance in Canada. Welcome to the show, Nina. We're so glad to have you.
I'm delighted to be here, and thanks for inviting me, Chris.
Yeah, and I have a little story to tell about Nina. So back in the day, when I was first starting out, employment law conferences, you actually had to go in person. There'd be like 500 lawyers or 1,000 lawyers in one of these huge rooms listening to people speak. And I was a young guy. I was listening to Nina give a presentation, and someone went up to the microphone and asked a question. And Nina was the first lawyer I ever heard say, "I don't know, but I'll find out and I'll get back to you." And later on that day at the conference, as I was gathering a coffee, I think during a break, I overheard Nina speaking to the person who asked the question and delivering an answer. And I'll never forget, that is how I decided I wanted to practice law. And I thought that was just a remarkable and awesome moment. And it actually kind of changed the way I approached the practice of law. So thank you for that.
What a wonderful story. I don't even remember the episode, but if I don't know something, I'll tell you because, I don't think lawyers should pretend that we know it all because we certainly don't.
Right. It takes a bit of courage to say, I don't know, but I can figure it out. And
exactly.
I learned a lot that day from you, Nina. So thank you very much for that. We're waiting for Ellen to join us back, but I'm sure we'll see her in a moment. In the interim, today's episode, we'll be talking about Williamson v. Brandt, a recent and fairly pivotal case in the Ontario Employment Bar. The episode focuses on two key issues today: just cause and the evidentiary threshold, and mitigation. Sarah, maybe you can walk our listeners through the details of the case.
Of course. Let's begin by taking a look at the employment relationship between Williamson and Brandt Tractor Ltd. Williamson was employed as a salesperson for 18 years. He was 56 years old at the time of termination. It appears that Brandt had a fairly hefty HR file on Williamson. The file contained several complaints from members of the public regarding his driving, a crash involving the company truck, and at least one instance of physical injury while on the job. Brandt ultimately terminated Williamson's employment for cause, citing a series of workplace incidents, and one in particular that resulted in a very angry customer complaint, which the company cited as the final straw. At trial, Mr. Williamson acknowledged the alleged encounter insofar as he tried to sell a customer a piece of equipment they did not have in stock and tried to get them to sign the contract without having confirmation on the financing approval. However, Williamson testified that this practice was commonplace at Brandt, and its purpose was to put the customer in line for the products as soon as they became available. Let's first focus on the issue of the for-cause termination. Do you think that Williamson's actions were sufficient to meet the evidentiary threshold of termination for cause? And I would also like to make a note, without giving away the results to our listeners, the trial decision was appealed. However, with respect to this particular issue, the decision was upheld. Nina, why don't you kick us off? Any thoughts?
So I have mixed feelings about this case. I do actually think there probably was cause, but I'm not sure that the employer was able to establish it on a balance of probabilities. Now, just cause, as any employment lawyer will tell you, is extremely hard to prove. And in this case, it wasn't just that one incident that they were relying on, but the fact that it was kind of a culminating incident. It was the straw that broke the camel's back. The problem that Brandt Tractors had is this was all based upon Mr. Williamson's alleged treatment of a customer. And it's noteworthy that the customer was not asked to testify. Anybody who does trial work knows that it's really hard to get a witness who's not involved, like a non-employee witness, to testify in a just cause case. But without that, what you have is hearsay on one side and Mr. Williamson's account on the other side. I also don't have the trial transcript, so I don't know exactly what happened. But Mr. Williamson's evidence that, oh, well, we kind of got people to sign up just to make sure they're first in queue, and this was normal. I didn't see in the trial decision any contrary evidence. So the evidence shows that the customer wasn't happy about signing something without knowing about the financing. There was also the customer complained about being badgered, 8 phone calls that he found to be very unprofessional and overly pushy, and he took his business elsewhere. But without the customer's testimony, you've got a trial judge who's saying, well, I've got some notes. I don't know if the customer's telling the truth in this. And I've got Mr. Williamson on the other side. And balance of, the onus of proof. I know that's kind of a nerdy term, but the onus of proof is on the employer to prove just cause. And they weren't successful. It's unfortunate because I personally think that maybe just cause could have been established here.
Well, so I think that's interesting, right? I had a similar read. I mean, I'm not sure if this is specifically channel stuffing, but it kind of has a whiff of that, the idea that the sales are greater than they actually are. And I also think, selling goods that you don't actually have is problematic. So, I
Going
understand
to
the,
get it. You're a
I,
distributor, you're expecting to
yeah,
get it, and you've got a confirmed sale. So I can see it both ways.
right.
And the fact that we are lawyers, Chris, right? So the fact that you and I are debating this without a solid evidentiary foundation is problematic for the trial judge, right?
Correct. And I agree with you. I think interesting. I don't know that you should be required to bring your customer to the trial in order to prove cause, though.
Well, but you have to
That
prove what
strikes me as
happened, Chris. You
fair
have to
fair
prove what
enough.
happened.
Fair enough, but that strikes me as putting a fairly high onus on the employer. I don't recall seeing in the trial discussion or in the evidentiary record was a last chance letter. And so I think if you're looking for a culminating incident, or I think if you're looking for a cause based on a straw that broke the camel's back, geez, I'd sure like to see a warning letter or a last chance letter. Like, we've talked to you about this before. We've given you remedial training. You still keep doing it. That,
Yeah.
wasn't there either, right?
I'm not
So,
sure. There's a reference to the fact that he didn't think he needed any training. Listen, I have a lot. I do actually represent a lot of automobile dealerships. And,
oh yeah.
it strikes me as Mr. Williamson, has that old school sales personality.
Mm,
And I think sales are becoming much more professionalized in the last decade. I'm not sure Mr. Williamson was open to those changes. I'm not sure that Brandt Tractors did the right thing at trial. I mean, it's all very easy to be an armchair quarterback. They may have tried to get the customer and the customer just refused or said, I don't remember. But, this is the type of case which I get on my desk. And it's one where I would seriously consider cause. But to take it to trial, I'd want to make sure that all my evidentiary ducks were in line. And sometimes you're at trial and it's just not possible.
right. And, you know, this is an odd case too, right? Because it's an older employee with 18 years of service, and he gets 17 months. And I think there's been a lot of discussion about how awards may be going up recently, particularly for shorter service employees. And so, whether or not the cause argument had an impact on the ultimate notice period that was assessed, it seems to me that 17 months for Mr. Williamson is at the lower end of the range of awards that I might have expected on these facts.
He's a
And so,
salesperson, though. And You know trial judges sometimes, split the baby. You know that, Chris, right?
hmm, Yep.
And I wonder in this case, I mean, Mr. Williamson probably didn't come across as the most likable person. There's a negative comment about his credibility.
Hmm.
He didn't try very hard to find another sales job, which was part of we're kind of sneaking into the second part of our
Yeah.
discussion. But, those are things that a trial judge does, whether they care to admit it or not,
Right.
consider in determining whether or not somebody's going to be at the high end or the low end of that range. I personally think it's probably bang on for somebody who's not in a managerial position, is in a sales position. And one thing I think we as employment lawyers have to get better at doing is adducing evidence of the job market. In a couple of cases, I've gotten specialist recruiters to essentially give me a letter. I don't think they're really experts, but just give me a letter saying, here's the person. If they make an honest job search, how long is it going to take for you to help them find a job?
Wow. So now
And
you're cutting to it, right? But that's something I want to talk about a little bit more.
okay, then I'll just, I'll back off a little bit. How's that?
Yeah.
May I ask a question just to bring us back to the cause? So I know, so the trial judge mentioned this cumulative misconduct principle. Can you maybe explain that for the listeners and sort of differentiate that from a single incident of just cause?
So, all right. So let's just try with that single incident. So a single incident is something so egregious that it immediately interrupts that employment relationship between employer and employee. And I sort of give the example of adultery in a marriage. Like it's got to be something extraordinary serious. It could be sexual assault, sexual harassment, fraud, theft. I've got a case where somebody falsified documents. It has to be something pretty serious. And it's a single thing. And you just say, look, I can't work with this person anymore. And no judge is going to expect me to trust this person to work with them. Rehabilitation is not possible. Cumulative incidents is where you've got things like a number of incidences, each of which are not all that serious, but taken together show a pattern of behavior that the employee is incorrigible and will not turn around their performance and will not meet your performance standards. And so you need to show a record of working with this employee, whether that is performance warnings and coaching, all of which have to be in writing and all of which have to clearly indicate that if the person doesn't shape up, they are at risk of losing their job. And so I think rightfully in this case, Brandt Tractors decided to go for that. This is the straw that broke the camel's back. This shows that he's not corrigible. This shows that there's no point trying to do further progressive discipline. He just won't follow the rules. So that was the way they cast their case. And I think if I were a trial attorney, I would do the same thing.
Yeah, I mean, I didn't get to see the submissions, at trial, but I would have been leaning very heavily on the fact that he called the disgruntled client after the fact and said something to the effect of, please don't tell anyone that I tried to get you to sign the second page of the standard terms and conditions on the invoice that he presented, right? So like for me, that demonstrates that he knew what he was doing was wrong.
And
Right.
there's dishonesty there, right? Because
That's right.
the old adage, it's the cover up, right?
That's right. It's not the mistake, it's the cover up. I agree. And so I agree with you. I think there was a stronger cause case here. I think unfortunately it wasn't documented well, and as you say, they didn't bring the witness. And I think that is a common failing in employment law. Sometimes, the mechanics of litigation are what they are. And if you're not prepared to engage with those mechanics, then you can run into some trouble at trial, right? And if you don't know what you're doing at trial, it'll catch up with you.
Well, I won't say that. I mean, counsel who was on for Brandt Tractors is well respected and very senior. What I will tell you as trial counsel is that you don't always manage to get the evidence in the way you had anticipated. So I'm going to give defense counsel a lot of grace because I've been in those shoes.
Yeah, no, fair enough. I'm not being critical of counsel. I think what I'm saying is that generally at a super high level, it is litigation. And sometimes I think it's easy to forget that because there are a lot of factors inside of employment law that are very human driven. The stories are very human. And it doesn't feel like commercial litigation necessarily at the outset. And there are opportunities for resolution, if everybody's prepared to sort of really focus on that, particularly early in the process, which is I think can be a little bit different than commercial litigation, where I think in commercial litigation, when there's a dispute and it's broken down and the companies rush to litigation, they gather their documents, they take their positions, right? And people get entrenched maybe a little more quickly.
Well, I still do enough commercial litigation. I think that, except for the big cases, like what I call the company betting cases, who owns this intellectual property,
Mm,
who owns this property, who are the shareholders, especially except for those cases where it's more of a contract dispute. I actually think that those cases also settle and, mandatory mediation or alternate dispute resolution, MEDARB, are often used even in commercial disputes. I can see Mr. Williamson being a very difficult employee. And sometimes I find, and I don't know him, so I may be wrong. But just from the way the trial judge described him, I sort of thought he was a bit of could be seen as a difficult employee. And, from my experience, sometimes those are the hardest cases to settle. Right. So for those of I do management side work, so full disclosure. But those of you who are listening in, who are plaintiff side or worker side, managing expectations at the outset and really making it clear that getting a half a loaf early on is better than fighting for a whole loaf at trial is probably the best technique you can use to make sure that something settles at something that everybody can live with.
right. So I don't disagree. Maybe I just want to talk about one more thing or ask your thoughts on one more thing, and that is, it's getting increasingly more difficult to tell employees what the range of notice might be in their particular circumstances. Short service employees, the notice periods are definitely, they can really diverge. And, unfortunately for older employees, again, more and more, you see the longer notice periods are the ones that get sort of not celebrated, but definitely reported, and broadly disseminated and discussed at conferences, and they show up on websites and firm materials. But those used to be the exception, not the rule. And I think there's a temptation, to see the things which are broadly published or broadly advertised as the rule now. And I don't know that that's the case. Like, here's a good example of a long service employee, an older employee. The cause defense did not succeed, and so it's as though there was no cause. And yet here you go, you've got a notice period that's less than 1 month per year of service.
Yeah.
What are your thoughts around sort of notice periods these days?
I do think that there is more unpredictability and that it's higher. I think it's a bit like climate change, right? More unpredictability and higher. So that's what I say. But I think that the best plaintiffs' counsels essentially ask, okay, realistically, you're not going to retire. Like if you're 40 or 50 or even 55, unless you happen to, be lucky and inherited money or, you're probably going to want to work and you're going to want to do a pretty significant job search. So realistically, how long is it going to take you to find work? Right. And I think that helps anchor the discussion in the underlying policy reason for these awards. How long will it take this person to bridge if they make a reasonable job search to the next job? But yes, I do think there's more unpredictability, but the best plaintiffs' lawyers are anchoring it in it with what is the reality for this employee?
Right.
And
it's still very much fact driven, right? It's
yeah,
still
it's
very much
fact-driven.
dependent on the
Yeah.
individual employee. And I think that's lost on maybe some counsel that I'm dealing with, maybe more junior counsel, right? But it's important, and I'm glad you said it because we feel it here in our practice too. And here, hopefully, we've got Ellen back now. Ellen, can you hear us?
Maybe.
Yes,
Hey, we
there you
can hear
are.
you.
Hey.
So apologies, everybody. Nina, not exactly
No,
a
no.
generous panelist for you. I apologize. Anyway,
It's okay. I've I've been covering,
I
and
know
I think
you
I've
Yeah.
been doing okay.
Yeah,
Yeah.
Nina's been killing it. She's been killing
The
it.
nice part about Nina is, I'm
So
prepared.
so we've been talking about the notice period. And so one of the things I had asked Nina Ellen was, hey, here's finally a notice period where somebody managed to get less than 1 month per year of service. And I've been suggesting that perhaps, people are too quick to celebrate the big wins and they're not, sort of advertising the cases where, you don't get more than 1 month per year of service, or there's a range, or you're at the low end of the range. Do you have any thoughts on, the notice period here or notice periods generally? We were talking about unpredictability as well.
And maybe pardon me, but I may have missed it as well. I think part of it is he's a salesperson. And salespeople are always tricky in terms of their notice periods because, on one hand, salespeople have really readily transferable skills. But then on the other hand, we have a line of cases in jurisprudence that say there really ought to be, like, while they may have transferable skills, sometimes they're in very niche markets and it may take them a very long time. So, despite the fact that you can maybe sell truck parts to truck guys, maybe that doesn't mean that you can sell ETFs to a financial bro. So, I think that that's part of it in terms of what he's doing probably makes a palpable difference in the fact that, based on the fact that he's in this kind of like niche area, maybe it's not 1 month per year for this guy. I don't know. Nina, you should.
I can tell you, Ellen, that, I live in the country and it is not a niche area. But yes, it's an interesting, but it goes back to, Chris, what we were discussing before, that it is really very factually driven in terms of what this employee with his age and his skills and his education is going to take to find another job.
So I think, Sarah, maybe why don't you wrap up the notice period here for us and tell us sort of what went down with the trial. And then we're going to move into the second part of this, which is fascinating.
The trial judge awarded 17 months notice to Williamson, considering the Bardolph factors and the special role that employment has in an individual's identity and life. The interesting piece in this case is that Williamson took a job driving a parts vehicle during the 17-month notice period, but the trial judge declined to deduct the amount earned from the award. So turning back to our panel, why didn't the judge consider this mitigating income? And my second question is, with respect to the appeal, why was the decision overturned? Lastly, do we agree with the final outcome in this case?
Who wants to go first?
Maybe I'll pass it over to Ellen.
Yeah,
Law school
you can
exam of
answer the law school
questions. Like, all
question.
right, well, let's take it from the top. Okay. So, on a high level overview, why did the trial judge decline to deduct mitigation earnings? It goes back to this case called Brake versus PJ-M2R Restaurants, Inc. And effectively, Williamson's lawyer argues that by taking a lower paid job driving a parts vehicle during the notice period, it's an inferior position. It's not as good. It doesn't pay as much. And so he ought not to have that amount deducted from the amounts that are otherwise at issue. Now, the Court of Appeal, interestingly enough, goes back to the trial decision and says that, unfortunately, the trial judge made error in relying upon effectively what was a dissenting opinion from Justice Feldman, or not dissenting, concurring, but differing in terms of reason and rationale. And the Ontario's Court of Appeal says specifically that there is no authority in Ontario for the proposition that earnings from a quote-unquote inferior position are exempt from deduction. So then the correct rule we have to default to in the majority holding of Brake is that any employment income earned during the notice period is generally to be treated as mitigation income, regardless of arguments about whether or not the position is inferior or comparable. Do I think it's the right decision? I think that was the next part of your multi.
That's a big deal.
It is a big deal.
Tell us why, Nina. Why is it a big deal?
Well, why is it a big deal? Because when the Blake case came out, and I think that was like in 2017, it was really interpreted as saying that if someone gets like an hourly job or an inferior job, but was terminated from a higher level job, none of that income could be deducted as mitigation earnings. I think that was actually maybe a false reading of Blake, or an exaggerated reading of Blake, because in Blake there were factual findings that she had always worked at one place. I still think that Blake was wrongly decided, or not as carefully decided as it should have been. But the reason the Court of Appeal in Blake did not deduct those earnings is because their position was, well, she was already working part-time at Sobeys, so we're not going to deduct her Sobeys earnings. She hardly earned anything at Home Depot, but $600 is $600. They should have at least acknowledged that that was mitigation earnings, but they didn't. And then she had some work at Tim Hortons, and I can't remember exactly why the Tim Hortons earnings weren't deducted. Essentially, what I think the Court of Appeal took this opportunity to set the record straight really is the mitigation earnings, are they possible because he's no longer working at Brandt Tractor? So if you have an inferior job, but it's 9 to 5, the hours that you were working at Brandt Tractor, then yes, it should be deducted because those are mitigation earnings. On the other hand, if he's, working at a Tim Hortons on Saturdays, I think we'd be back to fighting over the Blake analysis in 2017. Interestingly, in this case, the employer, Brandt Tractors, tried to argue that he did not conduct a reasonable mitigation search because he chose not to apply for sales jobs. Now, that's I've seen that happen where somebody says, look, I don't want to be it'd be like me saying, I don't want to be a lawyer anymore, so I'm going to apply for law clerk jobs. Well, no offense to Sarah, she's not going to earn as much as a partner at Gowlings, or if she is, I'm joining your firm, Chris. So,
You're welcome. You're welcome to.
Yes,
we'll have you tomorrow. We've got a desk. I'll clear some crap out of the back here. We'll get you right in.
I'll be there. But, so it's not a reasonable job search in my view to, say, I just want to drive, I want to do something mindless. I want to drive a parts vehicle. But it's really hard because I think a trial judge would be faced with, well, okay, he's just been fired from a sales job in a relatively small community, and people are going to want to know why he left Brandt Tractors. And if he's truthful, he's going to have to say he was terminated for cause because he botched a deal and was ungovernable. So I'm not sure, factually, I understand the frustration of Brandt Tractors because good salespeople can find a job in this industry. But I'm not sure Williamson would have really been successful given we know the evidence that came out that there were issues. And everybody knows everybody in every industry. I have learned that Canada's a very small country.
And Timmins is a particularly small
area. So
yes, exactly.
Yeah, for me, I think you've hit the nail on the head, right? Like you've been at the same place for almost 2 decades and you're out on relatively short notice, right? This wasn't a case of working notice. This wasn't where he had a chance to look, from a position of employment. So I can understand why he may have felt there were some barriers there. I think what's more important for me, though, is, in an era of side hustles and, my practice is here in Toronto where, it's not uncommon to have more than one thing going on at a particular time, or it's not uncommon to be employed in multiple roles or have multiple streams of income, as we like to say. How does this case factor into that, right? Are we still... For example, will we look at your Uber driving earnings pre-termination and post-termination, and will we deduct the pre-termination amounts, right? Because if you were earning that money on your own time, prior to the termination, why should it suddenly become mitigating income simply because there's been a termination? The other piece for me is, okay, so I've woken up in the morning, I've checked my job boards, I've sent out some resumes, I've even, done a few extraordinary things. I've called people in the business, I've organized some coffee meetings, and I've spoken to a specialized recruiter. It's 11 o'clock. So I jump in my car and I drive Uber. Why is that a mitigating earning? And more importantly, am I going to be punished in my wrongful dismissal litigation for being productive, right? Like I do have some concerns about the way the Court of Appeal restated the law. Like it could have been, like 3 paragraphs is helpful because I get the idea, that the court is not really interested in hearing from me on this. Hey, sort it out is kind of how I felt a little bit, but the direction is kind of blunt and it doesn't help. So now let's take the example to an extreme. Like let's say I'm a multi-million-dollar earning employee and I have multiple streams of income, one from my employment, one from a corporation which I founded, and I draw some income from that. And I'm also a consultant. Oh, and I'm on a paid board or 2. right? What do we do with that? Right. And how are we and how does this guidance help us? I mean, I think it still helps management a lot.
I think this helps management at all. And I think that this is where commercial law, where we try to work with damages and have to do some pretty extensive thinking around damages, you'll find that that will be needed for your hypothetical high earner who's got multiple sources. And I think you will see judges having to get into well, he was tracking 2 board appointments. That's not unusual for a senior executive to have a
Right.
couple of boards and that they can manage and juggle with a full-time job. And he had 3 speaking engagements in the last 5 years. But then once he became terminated or surplus, he took on 5 more board appointments or 3 more board appointments, and he essentially earned, like 20 speaking fees. And so we're going to have to look at the differential in order to determine what the mitigation earnings ought to be, right?
Ellen, dollar earned is mitigation?
Probably, honestly, based on just hard contractual principles from first year law school, like a dollar is a dollar is a dollar. I don't really want to spend a lot of time parsing apart whether that mitigation income is inferior, superior. It's not important to me. But I do think we need to be very clear, which I think is helpful from the plaintiff side, perhaps, is that the Court of Appeal in this decision does seem to make the distinction very clear between 2 factors. One being the failure to mitigate and the inquiry about the appropriateness of mitigation. And then the second question being, if that is so, then the deduction of actual earnings. So it's almost, like I hate to say it, but we're almost implementing a multi-part test to this, which is, let's get through that hurdle first of, has there been a failure to mitigate? And then let's talk about deduction of actual earnings with respect to those being 2 sort of separate things, because I find that they get conflated a fair amount, especially when we're having an ongoing notice period debate where we have a lot of pushback sometimes on the plaintiff side, where I will make submissions that an appropriate notice period might be 8 months, but counsel pushes back and says, but your guy found a comparable job after 6. So it's only 6, right? And we know that we're not supposed to do that. We're supposed to figure out the notice period first and then look at mitigation. So I think that part for me was at least helpful in terms of the distinction between 1, failure to mitigate, and then 2, how are we going to deal with any actual earnings?
All right. I think that's great insight. I do have one other question for the panel, and I've struggled with this, and it's come up on other podcast episodes, and so I'm just going to throw it out. But short of offering to rehire the employee, or short of the employee getting offered receiving an employment offer, which they then reject, I'm not aware of a whole lot of cases where the employer has managed to satisfy the second branch of the mitigation test, which is to prove that had the employee looked, they would have found work. And I'm not aware of any particular expert who's been called or who has been qualified to give expert testimony on this. And the real problem that I have with this is it puts on the employer the burden of proving, I guess, a hypothetical. Right? And we don't allow hypothetical questions in cross-examination because they don't add anything to the process. It's remarkable to me that we have this sort of hypothetical question at the very end of a wrongful dismissal trial, like it's the last thing, right? First, we do the Bardolph factors, then we figure out the notice, and then we figure out what gets paid during the notice, and we argue about whether the shares are in or out, or the pension is in or out. And then we look at mitigation, and the very last thing is this impossible hurdle for the employer to overcome. And so what I'm wondering, Nina or Ellen, do you have any insight on how employers can manage that second part of the test?
So I try not to do it at trial because I think that it is a bit of a what do you call a Hail Mary play. But there are judges, if somebody has done absolutely nothing and they've just kind of sat and what my friend says, binge watched to the end of Netflix, you can expect a judge to take a 20 or 30%. I know, like they'll say it's a range and it'll be the lower end of the range. Or some of them will be explicit and say, you know what, like I'm going to say what I'm going to do. And if the Court of Appeal wants to, overturn it, they'll let the Court of Appeal overturn it. And so when you're talking about litigation risk, there's a litigation risk. If the person hasn't really made any effort, they're going to lose 20 or 30% of their, range. And so all of us know that 95% of employment law cases settle. So you're not really doing it for the trial. You're doing it for the mediation or the settlement to say, look, your guy did absolutely nothing. Your guy told every single person that he wants to, tend to his tomatoes in Italy in his retirement, and he's spending half his time elsewhere. He's going to get punished for that. And, like, don't be overly greedy on your demands, because that will look very embarrassing for him. And so that's how you deal with it. I do find, however, in certain fields, like, it's not easy to do, but in certain fields, if you get a good recruiter's letter or a good placement person's or outplacement counselor's letter about, I work extensively with people in this industry and I help place them. Somebody with these qualifications will likely need somewhere between 6 to 9 months to find a job, or, should not take more than 12 months. That goes a long way to getting these matters resolved. And we know 95% of cases, Chris, don't show up in the Court of Appeal. They show up in our settlements briefs, right?
Right, but Nina, in fairness, right? Like, I'll play devil's advocate here,
Right.
so if you're not an enthusiastic applicant, you can easily submit 100 or 200 job applications, and if at every interview, you make it clear that you're only applying because your lawyer told you have to because you're suing your last employer, the likelihood that you're moving on to the next round of interviews is very low. But
Yeah.
I can't see that in a job search journal, and I certainly, as management counsel, can't call each interviewee. I can't call each prospective employer to find out what happened at the interview, right? Like, there's, to me, it seems like this second branch of the test is it's a bit unfair.
Yes. But I think that the response to that would actually be, your contractual obligation is to provide them reasonable notice. If you are going to try to reduce that contractual obligation on the basis that they could have done a better job mitigating, then the onus is on you. And I have to say that the employers who've done best at that, like, I remember a downsizing, now over 20 years ago, where it was a med tech company, and the HR director loved the employees that were being let go, and essentially said, look, I know people, I can network for you. Will you let me do that? So he had, I'm just going to make up a hypothetical, there were 20 or 25 people let go. Everybody found a job. And interestingly, the only one that didn't find a job was the one who said, no, I don't need your help, right? So that went a long way to sort of saying, hey, there are jobs there. There's maybe a little bit of a hidden job market. The HR director was essentially acting as a transition consultant, finding people jobs. And you said no to him. It went a long way to getting that one resolved. But don't expect as an employer, and I don't, even though I get frustrated, that if you're not helping the employee to find work and encouraging them to find work, or, like, I have one client of mine give me all the appropriate applications every Friday that I send off or they send off, you're not going to get very far in the mitigation. So one of my techniques is literally to tell the HR person, set up a virtual job search and send those applications. Because if this doesn't settle and we go to examinations for discovery, I'm going to ask which of these 822 jobs you didn't apply to. And
Right. Well, so again, so Ellen has, unfortunately, she's had a little technical difficulty, but she's sent in a case. It's Gannon v. Kingsdale. I love Ellen for this. She's got all these cases at the tip of her tongue. I'll just read it out quickly. 57-year-old clerk dispatcher with 20 years of service terminated when the employer's trucking business closed permanently. The employer proactively shared contact information for a comparable employer in the same industry, which offered Miss Gannon a full-time dispatcher role at the same salary and hours. She declined, preferring to see what's out there, and she pursued some online courses. The result, 0 damages plus a partial cost award against the employee. So, mitigation can be successfully argued, but that's akin to, sort of the one of the two categories that I cited earlier, which is there's either an offer which the employee rejects or the employer offers to rehire. I don't think that that's going to come up in a whole lot of wrongful dismissal matters, right? And so I do think that the test needs I think the test needs, frankly, I think that employers have to get more creative with how they're evidencing their case. I think, as we were saying earlier, you have to approach it, from a litigation perspective. If that's going to be the argument that you're going to make at trial, make sure you've got some evidence. I think there are some ideas. I'm not aware of anyone you could qualify as an expert. We had an economist come on the podcast recently, Nina, and we put to that reasonably sophisticated economist, we put to that economist, are there statistics that you could pull? Where would you look for these statistics? And he was quite clear that, even by industry, it would be very difficult
Yeah,
to
and
get
that's
employment
why,
statistics.
yeah, you know what I find? That's why I find the placement people are the most useful. And employers, my advice has always been get a good placement consultant, outplacement consultant for your employees. It helps them find work. It shows that you care about them. It's not as good as having a job, but it shows that you are trying to help them in this difficult time. Make it unconditional, no release required. This service is available. And, especially when you're doing these large RIFs, you've got some statistics to show if you do this type of strategy and you get a job and you're the only one who chose a different strategy, even though you were counseled not to, it goes a long way to resolving the case. But you're right. Mitigation is failure to mitigate is really difficult. And even when a job is offered and they decline, remember in the Blake case, which Ellen was raising earlier, this is a case where she was effectively given a demotion. And she said, well, I would find it humiliating because I would have to work for people that I had trained, even though, frankly, she wasn't cutting it in her position. And so in that case, her refusal to take the job, the alternate job proposed by her employer, was found to be perfectly reasonable. And I had problems with that. If you're not cutting it in your position and the employer offers you a job that is less likely to require you to improve on your weaknesses, then regardless of whether you're going to have to report to other people, maybe people who are younger than you that you may have previously trained, maybe you should be taking a very hard look at that job. And especially now where the job market is tough. So I know, the other case we need to be mindful of is Evans and Teamsters in the
Right.
Supreme Court of Canada, where they did offer him his job and he turned it down, alleging that it would be difficult for him to work with the new regime. And the Court of Appeal the Supreme Court of Canada gave him short shrift. They said he should have taken that job.
Right. Well, so I have one other strategy I'm going to put out to you, Nina, just quickly, and then I think we'll let Sarah wrap us up a bit. But one thing I've been experimenting with is unilateral payments. If you've got a long service employee and you're on for management, you've looked at the contract, and unfortunately the provision which sought to limit notice, it just isn't going to survive any scrutiny. So you're down to common law notice. Why not make some unilateral payments? Like for example, in this case, he's got 18 years of service. He's over 50 years of age. Why not pay 12 months notice before trial? So that really, when you're sitting there at trial, what are you arguing about? You're arguing about the last 6 months. But more importantly, now that we have this Williamson case, doesn't every dollar paid count as mitigating earnings?
So it's very difficult to persuade an employer to pay anything beyond even the statutory minimums in a cause case. But let's pretend that
Yeah,
this
fair enough.
wasn't a cause case. This was just a restructuring case, and we're all getting more of those. I often recommend if we're not getting to a settlement quickly, and let's say, think based on the information I have, this person should take 12 months. I sometimes recommend it. There is a perception in the employer community that if you make it too comfortable and there isn't the prospect of no income coming in, then employees may be less motivated to work hard on a job search and essentially take the long payment as a paid sabbatical. So I think that that's the other side of it. But yeah, I have in certain cases said this may be a case where if we think the right number is X, we just pay it. And that actually, it's good for two reasons. Many counsel who work on contingency
Yep.
work on the basis that they get X% of anything more than what is offered by the employer. So if you essentially, okay, let's say they are arguing for 24 months. You think 24 months is ridiculous, but you think, you know what? 12 months is probably really reasonable. If the person does a great job search or even a decent job search, they should be launched in 12 months. Then you offer transition counseling without any strings attached. And you say, you know what, we'll pay 12 months. All of a sudden, that becomes 30% of much less, right? So sometimes I find that helps settle it.
Right. I also like, when I'm on for a management client, the last thing I want to do is be standing up at trial and agreeing that the termination provision is unenforceable, right? And the judge says, well, if you knew it was unenforceable and you knew common law applied, why haven't you paid a penny beyond the statutory minimums, right? It's not a comfortable place to be because it's an uphill argument, right? Because it looks like you starved the employee.
Yeah,
It
does.
looks like you took somebody who, worked for you, particularly in cases where there's long service for a long time. And, even though you knew you had an obligation to them, you didn't fulfill that obligation. Not a great look, when you're looking, for justice from the court, or maybe you're looking even just for a reasonable notice period. Right. So I like unilateral payments. I agree with you, Nina. It's very case specific. I mean, it will work in certain circumstances. It doesn't make sense in others. I don't think this Williamson and Brandt was one of those cases.
No, but what we have a problem, Chris, which is, I've been in law for a very long time, Chris, and it used to be that we could get one of these cases into the courts to be heard maybe in 12 to 18 months.
Yeah.
And that's not what we're here. I'm hearing 3 years before we get a trial date. I had a small claims court matter that the settlement conference was in January of 2023, and we have a 1-day small claims court hearing in July of 2026. So when you have that type of long delay to be heard in front of a judge, sometimes employers will say, well, you know what, I might make a decision, but I'm not going to make that decision now. I do want to starve the employee now so that they're motivated to find work. And if I'm persuaded that they tried to find work and were unsuccessful through no fault of their own, then I might make a different decision.
Yeah, it'd be interesting. I mean, I don't know if there's if there's a way to track it statistically. AI will probably be able to help a lot of counsel with this. But, it would be interesting to know that, as the length of time it takes to get a matter to trial or into a summary judgment increases, and it is increasing, it would be interesting to see if there's a real correlation between that and what appear to be rising notice periods, right? Are courts aware, hey, like this person's had to wait a long time and maybe courts of justice interest is not sufficient to reward them, right? Because it's, where courts of justice act interest is at. But in any event, that concludes today's discussion. I want to thank our panel for the great conversation, Sarah for keeping us on track, and our listeners for tuning in. If you like this episode, please subscribe and leave a review. If you have a case you'd like us to discuss, or if you'd like to share your own story of workplace drama, and we love workplace drama, email us at watercoolerjustice, all one word, @gmail.com. Until next time,